time or sick time and coordinate. And if there's anything that's unusual, I will address it with the department head. But it's been real. I want to say it's tightening everything.
Yes, and that was a very important part of it.
Yeah.
Okay. Yes, David.
Once you're on the Chronos system alone, won't that cut down on your time on the manual? Well, doesn't the manual take a lot of time?
Oh yeah, it'll cut some of my time down.
Good.
Yeah, yeah. And then it makes it gives a awareness to all the department heads of policies. It's very helpful, and the employees.
Anybody else got any questions? If not, thank you, Kathy.
Yeah.
Would you?
Thank you. Yeah.
Would you stop and ask Tom Dewhurst to come in?
Yeah, I believe his is going to be non-public.
It is?
He mentioned that. He called me yesterday.
Oh, we should have been later.
Something about...
Well, I think he can talk about the right to know law. That doesn't have to be non-public.
He thought perhaps whatever he... So you can address it with him.
Okay, yep.
I thought he was coming to talk about why we can release the non-public minutes.
Yep.
That was going to be public.
Yeah.
Yep. Yes.
Madam Chairman, I've expressed this before. This question of meeting off, I won't say off the record, but first of all, you said the non-public meeting that you all attended was posted.
Okay.
Where is it posted? I'm sorry I don't drive up here every day at 8 o'clock in the morning to see what's posted for the day.
Maybe I should have said it was an emergency meeting called by our attorney last week after the last meeting. I think it came in like on Friday. Can you meet on Tuesday morning at 11 o'clock with another firm? So it was it was after our last meeting, so we couldn't announce it then. We didn't know about it happening then. And it was regarding, what was it called? Contracts, negotiations, so it would have been non-public anyway.
Okay.
So you were notified on Friday?
I think it was Friday.
Because I get notified on Monday late afternoon that I had to be here Tuesday morning at 11.
Maybe it was Monday then he called. It came in by email, and I didn't have email, so they called me from the office.
Are we talking about yesterday or last week?
About yesterday.
Yesterday's meeting.
Yes.
Well, that leads to a further discussion.
Yeah.
Whether Commissioner Solomon, God bless her, likes to arrive here early so she doesn't miss anything, and you're in there, 2 out of the 3 constitutes a public meeting by law.
But it wasn't.
And I understand that. And that's one of the problems you have, all being housed in the same room. And I don't know how you get around it, except that when you come to these meetings on Wednesday, that you let the public know that you held these things and what was discussed. I don't believe we would have even known the lady was here from the landscaping company if Commissioner Kenny had felt she was left out. We wouldn't have known.
Yeah.
We don't have the same feeling that we had 4 years ago, where there might be some deception going on, to use that's cleaned up. But we do feel, because you seem to do most of the talking in these meetings, Commissioner Solomon and Commissioner Kenny very rarely say anything. So to run this facility, I understand that, but to run this facility, you have to be meeting somewhere and discussing something, or else you're making all the decisions here on Wednesday morning, and I know that's not happening.
Well, I'm not sure. If you get some things that you think making decisions on, then bring them up, because.
Well, I don't know. I just don't have that feeling of openness that I've had in the last maybe 2 years.
I give everybody an opportunity to ask questions.
Yes, you do.
In between speakers, rather than at the beginning and at the end, and have those two.
I'm
not sure.
And here I am speaking.
Okay.
I think frankly, he is the chair of the commissioners, and therefore he would be the one to articulate what's going on. I see nothing, nothing wrong with that. It makes sense. And so when I have something to say that seems pertinent, I will say it. But if it's, if it's not pertinent to fog up the meeting, what's the point?
Well, I'll give you an example. I can't be specific, but I can give you a rough idea. You'll get a contract in here, and you'll go over the 3 bidders, and you'll take a vote.
Yeah.
Now, I would like to hope somewhere along the line, you 3 have done more investigation on that, on the 3 bidders, than come in here in 2 minutes, say, okay, well, let's go with $30,000. Now, I hope there's some business being conducted here in a professional manner, and that's why I don't question what goes on downstairs, because you've got to run this business. But some of this stuff, I think, there ought to be a little more depth in some of these discussions.
Regarding that example that you gave, in most cases, wherever that bid comes from, maybe it comes from Jason, he's going to come in with 3 bids. It's going to be public. I don't have any privileged information until he brings those bids in here. And then we will act on them. And normally, same is true with Bonapage and Stone. All those subcontractors that we dealt with, they came in with a recommendation and some information on each one of those subcontractors as to which one they would recommend getting the contract. So, I mean, that's where it goes.
Okay.
I mean, I do talk with Will about the haying operation and what's going on. I met with him yesterday afternoon. He's getting in a second cut. I don't know what he reported on this morning, but...
That he was beginning a second cut.
Second cut. All right.
Thank you.
Okay. I have no reason to hide anything.
Well, Mr. Chairman, I'm not accusing you of that. I'm just... in some instances, I think some of these things call for a little more depth.
Okay,
and
bring
unless
it
you're
up.
conducting them downstairs, which is fine, as long as we find out when we come upstairs that this is what happened, I'm okay with that.
Nothing is decided downstairs. All the decisions are made here.
Okay. Thank you.
County Attorney, I hear that you wanted non-public, but can you talk about the right-to-know law as to how we would, what do I want to say, let out the non-public minutes of previous meetings? Can you talk about that in regular public session?
I guess I'd have to know specifically what you want to review, and then we'd have to follow the statute, I guess.
Well, I think you meant about the non-public minutes, what we can release and what we cannot release. I think that's the question.
Right.
There's, in the past, about every 4 months, 6 months, a lot of the action has been taken in the non-public session. And I guess the question is, should that be released, or shouldn't it be released? Would it be damaging to those involved in that decision? Whether the decision was positive or negative, would it affect that company or that individual?
Well,
by releasing it 6 months later?
The problem is that people go into non-public session for various reasons, various exceptions or delineations under the elaborated to do so. And when you go in and then those matters are either discussed or elaborated on, and then things change, the matter would have to be re-reviewed for all the content and the particular parts that may be protected or not protected under the statute, and then a decision would have to be made in non-public by the commissioners to release or non-release of those portions.
Okay, let's
because things may come out of those discussions that may, then suggest matters that should be discussed in public or released to the public, and that would be on a case-by-case basis. So I don't think there's a generic or a guideline that you can use in public to decide what should be or should not. But I think that if it's a concern of the general public or if it's a concern of the Commissioners Board, that these just be reviewed and then a decision made.
Let me give you, let's see if I can give you an example. Let's say that we contracted to have a windmill put up on the mountain, and that was done in non-public session because it's a contract. And let's say that they defaulted and we took them to court or went into some kind of an agreement, settlement. And that's all done in non-public. Now, how much of that could be released to the public?
Well,
would it affect the company that has the windmill? Does that damage them because of something that happened?
There are, as I said, there are parts of the right to know law that protect the reputation of a particular agency dealing with a municipal body. And then there are requirements to disclose settlement amounts without detail or based upon settlement discussions that are either protected or non-protected in those types of meetings. So it's not clear-cut is the answer.
I recall, though, that I believe there's an RSA that says you need to release the amount that was spent.
Yeah, and it depends on what the nature of the dispute, litigation, and it requires a careful analysis. I mean, because you can get into contracts, you can get into you know, what the issue is of the non-public, and it's not as clear cut as it may seem from the public's point of view, but it's also an obligation to protect the privacy interests of the individuals involved.
In putting out non-public minutes, can you redact things and still put out the information that is good or is okay for the public to have?
That would be case by case, Dorothy, and I'd have to look at what is actually being released and how it is being released and what the effect of the release in the redacted state would be. We have general guidelines for redacting in criminal prosecution, but that's a whole nother realm than what we're talking about here.
Go ahead, Representative Abson.
I read the law, Tom, just last week, and I think it says if it's going to libel somebody, you don't have to disclose it after it's been adjudicated. But you also have to do it in good speed. That's been a concern here. We haven't had any non-public minutes released either since last October or last December. I can't remember which. I'm sure that all of those cases are not personnel. I mean, Lord only knows the last batch we got before Commissioner Webster left office was one of them was a fight over who was going to get their parking lot plowed first. Remember, Maureen? And you know, that's not even, that shouldn't even be public, non-public session. But B, if it were, when that was settled in January, in the next snowstorm, that should have been made public. It wasn't made public for another 8 months. You can't go over all of these cases, I understand that. But we shouldn't be sitting here wondering what's going on for 8 or 10 months on these minutes. Some of this stuff can be released right away. If you got a dispute with a contract, I don't know how you libel somebody if one party says you didn't fill the contract and the other one said, yes, I did. And somebody says, well, no, you didn't fill it. How can you libel him if in fact that's what the court said?
Well, I agree, Dave, that there should be due diligence in looking at these types of matters, and but I find that the records management in municipal government, especially when you have large projects going on and issues that some